Are you ready?
Well, that wasn't confusing at all.
Anytime you get stuff where there's in county versus out of state, it just,
No, it's all.
there's just so many rules that just kind of
And Judge, I'm
clears mud.
No, I know. I've seen those issues and have dealt with just enough to know I don't enjoy them.
Is our guy on docket today?
No, well, he's on docket.
Hold up. This guy got bond after daring cops to a street fight? Either Texas has the most chill bail system, or there's a mental health twist coming. Spoiler, it's both. Buckle up.
But he's here present in court. He made bond, so that I guess that gets rid of the issue about having to
Coming up.
BVR.
Last name again?
Gomez, and it's Matthew Gomez. You may have a couple on the docket.
It should be not showing.
And did invite us to rehear PC this morning. The case I know is 183 days old. I have talked with the state. They're still trying to work with felony to see if they would approve him to do a mental health PTI, which we thought was appropriate.
Mental health in the case upstairs or our case?
Yes.
Are you ready for a PC? Blaze?
So, Your Honor, I think our understanding was the screening of it. I didn't know if you want the actual officer here or not.
No. This is just cursory, but I want to know if you're ready for any arguments or whatnot. Yeah. Okay.
We're not addressing the new one whatsoever.
Yeah.
No. That's
totally done.
Tell me. Go for it. Alex, please.
Judge. On August 25th, 2024, the officer was dispatched to a complaint unknown call at Harris County, Texas, with the call slip stating the following. The caller was rambling and refused to answer questions. The caller advised he has warrants for arrest and wants police to pick him up before he does something. The caller states he will be waiting outside the location for police. The caller was irate and upset. The caller was making threats towards police, stating they better be strong because he was going to fight and don't dispatch female officers. The officer arrived on scene and immediately noticed the defendant coming out of his house in an aggressive manner. The defendant took off his shirt and hat and was coming towards the officer quickly and was trying to get the officer to physically fight him. The defendant repeatedly stated he wanted the officer to fight him, and the officers immediately drew their tasers and began giving the defendant verbal commands. The defendant repeatedly refused to comply with the verbal commands and continued telling the officer and his partner to put their tasers away so they could fight him. The officer took the defendant to the ground by tackling him and used force to put the defendant's hands behind his back. The defendant was physically resisting and yelling the entire time. The officer then got the defendant into handcuffs and moved him to the side of the patrol vehicle. The officer's partner held the defendant against the vehicle while the officer conducted a search. The defendant was still refusing to comply with verbal commands and was physically resisting. The officer then assisted the defendant into the patrol vehicle using the minimal amount of force necessary, and the defendant was kicking the officer's legs and still refusing to comply.
Did they find anything? You said they searched, but they didn't find anything?
There's no finding anything or completing the search, and they only know that they arrested him on the warrants as well as the additional resistance charge.
What warrant did he have?
He had municipal.
I'll give you a second.
Municipal warrants, Your Honor.
Just municipal?
Yes.
Okay, all right.
Yes, but I think a couple things are, and I know that's the DA's summary of the longer dims. And the longer dims notes reflect that when the officers got to the scene where they had been asked to come out and make an arrest and or been asked to come out and told there's warrants, but they get there and they don't have a chance to confirm anything or find out who he is or any of that stuff. But what's written in their longer dims report, the officers write down, he asked us to put our tasers away and fight him. And so it says in there that the officers made the decision to put their tasers away and go hands-on with him. And so that is...
You're saying, you're telling me that they agreed to fight him?
It's what they...
Wait, did these officers legit holster their tasers because the suspect said no guns, just hands? That's either next level de-escalation or a lawsuit waiting to happen. And the DA's side-eyeing this report hard.
Can you imagine how much possible trouble they would get if they would agree to something like that?
And I don't think that it's agree to fight him in the sense that, I'm not saying the officers did anything wrong whatsoever. I'm saying when you arrive on the scene and somebody says, I have warrants, we know that's not enough as a legal matter to make an arrest. I could walk up and say, I've got warrants to our deputy. I can't be arrested for that. Maybe he can go back and find out more information, but that's not enough.
I think that's reasonable.
Yes.
Yeah.
But then the conduct is not that he comes up and starts fighting with the officers, but invites them to engage in physical contact. And I give them credit for putting their tasers away like he requested. But they, right in there, we did exactly what he said. We put our tasers away and then decided to go hands-on with the suspect. It's 2-on-1.
But I don't think the reasonable interpretation would be that they are agreeing to fight.
Well,
I don't think that that's reasonable because I can't imagine how much trouble they would get in, you know? They'd be fired.
to me, it's not about whether no one over here, and I don't think the state is either, is saying that the officers did anything wrong. I think we're assessing his conduct, and he has the right, as does anybody, it's just First Amendment protected speech, to invite someone to engage in physical conduct. And if they do, that's not him resisting arrest. And I don't really even think that that's the kind of the basis of the charge. They can't even arrest him because there's nothing to arrest him for at that moment. If you ran his name and found out the warrants and found out he did have active warrants, you could arrest him. But there's nothing for them to even arrest him for at that moment. And just walking up and saying, hey, I want to fight you, that's not enough to be placed under arrest. But what happens is they get him and get control of him and then start searching him. But pursuant to what? I mean, there's nothing. They still haven't verified him.
No, I think that it's so difficult to be a police officer nowadays, you know?
I understand.
A fine line that you have to walk between because of
Let's be real. This whole scene is a minefield. Cops face instant backlash if they tase someone in crisis, but also get roasted if they brawl. Meanwhile, the law's like, was that arrest even legal? No wonder this case is stuck in limbo.
because of social media,
Sure.
because of cameras, because of just the way that the public policy and people come down on officers and how they react to situations and how they can get in trouble themselves, that if you see a person who's not acting normal, they're having like a mental health episode, how do you quell that down? Do you tase them? Because we know that we've got situations where officers go rogue and they just start
Sure.
kill them.
No, well, we've seen it too many times. And
And it sucks. It's sad, but
I'm not criticizing the officers one bit about that. If it's the case that he tells them, when you get here, I want to fight. And when they get there, he says, I want to fight. And put your tasers up and fight me. And they put their tasers up and decide to go hands-on with him. I respect them for having done it.
I would like to know, because I'm not prepared to rule on this. What I would like to know is, what is the policy of the department when you have a person who's having a mental health episode? How do you handle that? Do you arrest them as like a community caretaking, right? Because in an effort to prevent them from hurting themselves or hurting another person, do you arrest them, right? Or what do you do? Because I don't know. So, because that's what's happening here. We have someone clearly who's having a mental health episode.
And you see why I thought mental health PTI is the appropriate route.
Yes, absolutely. Yes.
So, and I don't mind being patient while you think about that, and I go back
I'd
and
like to know what the officer's mindset, number one, at the time of when this episode is happening. Number two, what is the policy when you have this kind of thing happening? What do you do? I don't know. You know,
Sure.
do you arrest them in an effort to prevent them from hurting themselves? Because who's to say they might have a gun that you don't know about that's stuck right here that they're going to gun? They're just going to start shooting.
Well, but I do think that it doesn't mean that he has done something legally wrong to elicit the words, this is what I'd like to do, and wait. It'd be one thing if he comes and starts attacking them, but to say, put your tasers up and fight me, and they say, taser up. We go hands on. Hands on for what?
I think that was extremely brave of the
Well,
officers.
and I'm-
I give them so much credit because, I mean, who's to say that he doesn't have a gun behind his back and they
Well-
just don't know? And they're trusting him that he's going to act honorably and not take a gun from behind and kill him.
I think it's what they said, Your Honor. They actually used less force than
Yeah,
would have been.
really.
allowed.
God, that was freaking awesome.
Again, this is not criticism whatsoever.
Yeah, I understand.
But
I
the
understand.
question is, what legally did he do wrong in that moment? One, to support a detention. Two, to allow for an arrest. And I don't know that there's enough for that. Or either one of those. It may be enough to, I mean, I don't know if I walked up to our bailiff and said I have warrants, if that's enough for him to even detain me. I mean, there's just no corroboration whatsoever.
So if you have someone that's coming up to you and threatening to assault you, right? Is that a
Well,
crime?
well, yes, but that's not the
There
same.
you go.
Well, no, that's not the same thing, Judge, because I can walk up to somebody and say, hey, would you like to fight? And that's different. That's not threatening
But
to
you
assault.
have to take the circumstances into account. There's a totality here. You
Well-
can't just take the statement in and of itself. The person's having a mental health episode.
Sure.
They're irate, right? You don't know what they're capable. You've never met them before. If I know you and you ask me to fight, that's a different question.
Well, but I don't know.
Versus I've never met him.
Turns on.
He's got warrants. He may have a freaking murder warrant out.
Sure. Well, but
They
in
know
order
about
to-
it because it's on the call slip.
well, they know that he said that.
Okay.
They hadn't verified it.
I understand, but it's still there and it's still in their mind. Damn, this guy's, there's a crisis here. How do we avert this crisis from happening?
And I respect that portion of it, for sure. But from analyzing whether or not there's probable cause to support the elements of this charge, I think that's where our focus really is at.
There's so many like branches to this thing. I can't possibly rule right now.
No, fair enough. And I appreciate that.
And I think just from the state's perspective, I know that we want to get a little more information on it. I respect that. I think you have, just looking at the totality of the circumstances here, you have a call slip that says someone is, I think what the exact thing was,
Yes, warrants.
rambling and refusing to answer questions. He's advising he has warrants for his arrest and wants someone to pick him up before he does something. States he's waiting outside. He was irate, making threats towards people. They, at the bare minimum, have someone that could be a danger to themselves or others. They go out, and I know this is somewhat peculiar to say, but he approaches them in an aggressive manner with his shirt off, saying, "Come on and fight me." I would argue at the bare minimum, they have the right to detain him. A, to confirm those warrants, because they can't confirm those warrants without actually speaking to him, getting his ID, that kind of thing. B, then there's saying, "Come on and fight me," to a uniformed police officer. I know you're not ready.
There's just too much. There's too much.
That's,
Well,
You're incapable of verifying the warrants because of the episode that's happening. So
but the actual charge in terms of the elements of this case are that he resisted a search being effected at the end of the fight. And all I saw there with respect to that portion of it was totally conclusory. And so that's where we think the PC falls apart on the element side of just this particular charging issue. And, but I want to again make it abundantly clear that we're not criticizing the officers whatsoever.
I know you. I get, no one is
It is a complicated situation.
taking it in any,
But we did think, and that's why the case has gotten to be 180 days old. I think we're at 182 right now, is because I've been trying to find out more and trying to work to get him approved for the mental health PTI, because that kind of
is now
fits.
what happened upstairs going to throw a wrench in it?
Yes, it has currently. They're going to reapproach felony and see if they'll still allow us to go down that route. But I think it's really the most appropriate route. And I'm not going to go into that case upstairs, but the allegation in that case, and I think legislature's made that a second-degree felony, if I'm not mistaken, assault of a peace officer. But the allegation is that his thumb.
Second degree.
Wow, the legislature made it a second degree now?
Yes, Judge.
Yep. And
Yeah, holy moly.
and I understand.
Wow.
But the allegation upstairs is, and I know there's different components to that whole fact pattern, but the allegation made the basis of the assault is that when they were trying to reposition his handcuffs, his elbow hit the officer's thumb. So it's not.
Oh, I thought here when they were reading it, they were saying like he was kicking and screaming and kind of
On
like,
the older case, Your Honor, he was. On the newer assault case is whenever they tried to put restraints on him, he pulled away and struck the officer's thumb with his elbow. That's for the felony, Your Honor.
it'll be interesting to see if there's body cam to see what the nature of that
Sure.
pull was, right? Because that's ultimately, the case lives and dies on probably that,
But
right?
from my perspective, and I hope that felony is in agreement with this when they learn kind of more about it, and it's a brand new case for them. But when they learn more about it, I hope that everyone agrees that
Sure,
if
I think-
there's mental health issues, then we solve that problem. So this young man isn't back here. And if he gets
We're
resources.
very lucky, my friend. Very lucky. People have died for a lot less. You got to be very careful in today's society. People have, you never know who has a gun. You know what? I have a friend of mine that had a person that was road raging behind him just because he wasn't driving fast enough. The guy comes out, gets a knife and stabs him. Did nothing just because he was driving slow. You never know who you're going to run into these days, man. It just, you run into the wrong person for a lot less, they'll shoot your ass dead. Gotta be careful, man.
And the advice that I've heard you say it in different ways is don't make permanent decisions based on temporary emotions. And
Life's just too short, man. You know, you get one crack at it. Once it's gone, it's gone. Just, all right. I'll do whatever you want to do.
Yeah.
I'm not ready to rule in it yet.
But I do think, also, I was asked to get bond conditions put in place while he's on a new bond. And what I'd like is the same old bond conditions. Don't
What do we have now?
be a new offense, don't consume alcohol or.
Just be good. You know, 99% people lose self-control. That's why they're in jail.
Yes, sir.
No self-control. You got to think. If I do this, what's going to happen? If I say this, what's going to happen? You got maybe a nanosecond to think about it. But that's what it's about. That's what makes you mature. Look at all those freaking old guys in there. Never grew up. Never grew up. And they'll never grow up. Yeah, I'll stick with the same bond conditions. Just no alcohol, no dope. Don't use, man. You know, is he taking any medication now?
No.
Okay, just be careful, man. Self-control. Got it?
Yes, sir.
Just stay in touch. All will be good.
Yeah, it's been great contacting me.
Okay, I believe it. Okay, Mr. Gomez, good luck.
Thank you as always. Thank you, guys.
Your Honor, I am here on Mr. Enrique Rodriguez. I received email from pretrial services stating that my client, Mr. Enrique Rodriguez, failed to go and to pretrial service and pick up the portable device.
Is Mr. Rodriguez here now?
Yes, sir. He's here, Judge. Mr. Rodriguez, come forward, please. I think he was supposed to get it by 1:13:25.
You don't have the devices we ordered you to do?
No, sir. I have a letter from the State Department of Transportation in Austin saying I am
No.
not ordered to drive a car, so I figured I didn't have to get it. So I can't drive. I didn't know. After since I can't drive, why should I get it? And then
Because I ordered you to get it. And now I'm revoking your bond and I'm putting you in jail because you've been a whole month without having it. You decide on your own? Courts don't work like that. It goes with you.
Thank you, Judge.
While Mr. Kim's on Zoom, I'm approaching, I spoke with my client. My client would like me to approach to ask for a bond so he could go and turn himself into the demanding jurisdiction, Worcester County, Maryland. And so
What's the last name?
his last name is Mr. Baptiste, P-A-P.
Good morning, Mr. Baptiste.
Good morning. How you doing?
So I don't know, I don't know anything about you. I don't know what you're wanted for. I don't know what kind of criminal history you have.
Hmm.
A lot of times, whether we give a bond to someone depends on what they're charged with, what kind of criminal history they have.
Mhm.
I know that you're going to tell me it's little bunnies jumping in the woods, but everybody tells me this guy's purple,
Understand that?
blue, black. So, but paper really tells me who you are because that's how we get to know you in the short time that we have.
No problem.
Mr. Kim, would you like to tell me about him?
Your Honor, he's wanted out of Yavapai County, Arizona for 6 charges, including fraudulent schemes and artifices.
Wrong case.
Oh, hey,
Wrong
that's
case.
me?
Oh, sorry, wrong case. He's wanted out of Pasco, Florida for battered
Oh,
prior.
that's not me.
Wrong case.
0 for 2, man.
Where are the ones?
Baptiste.
Maryland.
Hold on one second, please. Oh, here we go. Sorry, I was reading a different warrant. Okay, he's wanted out of Worcester County, Maryland for theft, but he's wanted out of 6 charges. 1, 2, 3, 4, 5, 6 charges, including fraudulently intending another's identity to use that information to obtain a value of item and currency totaling a little north of $80,000. He's currently on a deferred adjudication for an aggravated assault. And prior to entering in the deferred adjudication, but after he was charged, he was also charged with carrying a handgun in a motor vehicle. State would be opposed to a bond, Judge.
So, okay, you went kind of fast on. So he has 6 open charges in Maryland or just 2?
Yes. So he has one count of $21,455.50. He has another count of $10,700. He has another count of $10,695.50. Another count of $42,851. One count of fraudulently intending a possession of personally identifying information, and another of fraudulently intending to obtain another item of or identity, assuming an identity of another individual to obtain an item of value.
Are all these? Is it like a theft from a person?
It was a fictitious wire transfer for at least one of them. I'm looking at the affidavits. One is routed through PNC
Do we have
Bank.
actual complaining witnesses or victims, especially on the one that's like a 40,000 gig?
That one I can hold on. Here's an account withdrawal. I mean, I can't tell if it's from the bank or from another. If I could just have 30 seconds, I'll take a look at the.
And how old are these cases? Are they new or are they old?
These are relatively new, Judge. This one is from June of 2023. So obviously it was after he entered in the deferred adjudication for the aggravated assault. Obviously violating his conditions of the aggravated assault.
Let me tell you the problem that I have, Mr. Baptiste.
Okay.
And the way you conduct yourselves in court and the way that you conduct yourself while you're on probation tells me a lot of who you are and whether you will submit and comply with court orders. Because one of the things that we have is when I give you a bond, you have to go turn yourself in to the demanding jurisdiction within 2 weeks.
That's no problem.
Great. Well, the first thing I did was I wanted to look through your history with the probation that you're on. And in the first thing that I pulled up in this bond violation report, I have here, 5th violation report submitted for failing to report to the bond unit as scheduled. This is the alleged probation that you're on.
That was waived.
Stop. I don't want you to explain anything.
I know.
The only thing I'm trying to impart to you is the way that you've been on your probation and the fact that you've picked up the 6 cases in Maryland in 23 or 24, whatever it is, and the amount that it is, tells me that it scares me to give you a bond because I don't think that you will comply. And it's unfortunate because I don't like to keep people in, but the reality is paper tells me who you are. And all those bond violation reports, the 6 new cases. Sorry.
Things, if I may, the
Sure.
6 cases, it doesn't make a distinction whether there's 6 separate transactions or it's all one happening at one time. And so he hasn't been able to answer for that. This is only from 2023. He would like an opportunity to do so. He is going to work out his felony case when he gets up there tomorrow. He's going to have a chance to work it out. I don't know if he'll be able to work it out or not, but it's his first opportunity to do so tomorrow. If he makes bond up there, would you consider giving a bond then? No.
It's just the way that the probation has played out. And the fact that he has 6 here, I think in my heart of hearts, if I set you a bond, that it's just, you're not going to show up. You're going to do what you want to do because that's what history tells us.
Okay.
Sorry.
I understand. Thank you.
Okay.
Question. Would you mind explaining to me?
This is not, no. This isn't where you get to do what you want to do.
Let's go. All right. Thank you.
Ask your lawyer, and then if it's something, we can talk.
Thank you, Judge.
Thanks. So tell me what we're doing with this.
Judge, this is a fugitive case. Mr. Day, I believe, is on Zoom. I am requesting to see if you would consider giving him a bond so he can go turn himself into it's Yerepe County, Arizona.
el condado de Yerpe en Arizona.
The lawyer is asking for me to set you a bond, Mr. Pasos Miranda. I don't know.
No sé.
I have to look at several things to see whether you would be a good candidate.
A ver si eres buen candidato.
Number one, whether you would actually go back.
¿No?
Number two, are you a danger to our public?
Segundo, eres.
So, Mr. Kim, tell me about Mr. Pasos, please.
Quiero saber sobre el señor Pasos, señor Ken.
Yes, Judge. This is the one from Yavapai County, Arizona,
Es que este es de País County, Arizona.
and he's wanted for charges of fraudulent schemes and artifices.
Por
Fraudulent what?
Schemes and artifices. This is just how it's written.
Schemes and artifices?
Fraudulent conspiracy to commit fraudulent schemes and artifices.
cometer
Okay.
fraude,
One count of computer tampering,
artificios, parece.
one count of theft,
Una cuenta de alterar computadoras.
and one count of criminal damage.
Uno de daño criminal.
So 4 total counts.
But it's out of the same transaction, Judge,
Casos.
on
Sí.
March 20,
Por la misma
2023.
transacción que ocurrió en marzo 20 de 2023.
State would be opposed to a bond.
El Estado no quiere dar, no está de acuerdo con una fianza.
For these charges, it looks like he messed with fuel pumps at a mini mart.
Estaba haciendo algo con las bombas de petroleras ahí en un minimart,
To include computer tampering,
incluyendo que estabas alterando algo con computadoras.
but 1 year after he committed these offenses, he
Un año
also was
después que
charged here
cometió este delito, también lo acusaron aquí
for a similar offense of violating motor fuel tax requirements.
por violar los requerimientos de impuestos de petróleo y
And-
vehículos.
And briefly before that,
Y antes de
for
eso,
a misdemeanor charge of theft, but again,
un delito
regarding
menor de
fuel.
hurto, pero igualmente era de
He
petróleo.
also has a prior fugitive case, I see.
Tiene un caso antes de
I
fuga.
didn't see that when I pulled it up.
From 10/31/24, I see a prior fugitive case out of the same jurisdiction.
La misma jurisdicción.
Yavapai County.
Yavapai County.
So he's been before you, is what you're
No,
saying?
it would happen if he was
lo que
a
dice
fugitive and he
que
was
era
apprehended
fugitivo
by
y
another state.
agarró otro estado.
It could have been by this warrant or another warrant,
Pudo haber sido esta orden de arresto o otro.
Oh,
Una
But be-
otra
but
arresto.
because it's resolved, that's why it's closed on our end. And I
but let me
can't
ask you
find
this.
it.
Did he know about this in 2024? Because if he did, I'm not giving him a bond.
He's saying he didn't know, Judge.
I see state jail. So I see a fugitive case and I see a state jail sentence of 7 months, both on the same time out of work.
Estatal de 7 meses.
So it looks like there
Entonces,
possibly could have been something that he pled to in Wharton County.
se declaró
And he got
algo
also
en
hit with
Wharton
fugitive
County.
case.
Y le
Because he
dio un
got
caso
7 month
fugitivo
sentence, they
y
probably,
como recibiste 7 meses.
fugitive case.
No fueron.
This is a lot of, we don't really know what happened.
So
Judge.
let's do this. Let's roll it to tomorrow.
I've had him in felony,
Dice
and
que
I
yo
know that he
estado
pled
en el
to
caso
the
de
7 month
felonía.
state jail.
Sé que
And then
te
he was brought over
declaraste
to Harris County.
culpable
I don't know if that
por
helps, but
7 meses.
I
en la
Represent him on the fuel tax in the 185th?
cárcel.
Yes.
Ahí es donde voy
Oh my
a-
He did.
What are the
That's
odds?
just opportune.
Huh?
That's why I'm like, if,
Let's go play the lottery.
so, if that help, I don't know if that helps, but he was
So-
brought over.
Ella fue
from-
tu abogado, dice.
Sí,
Está hablando.
Did he do 7 months state jail? Because I show a sentence
No,
of
that's
7
still
months.
pending. So they're
No,
going to
dice que
send
se
him,
está pendiente.
Still pending.
todavía.
right.
7 meses de
Yes.
cárcel.
Yeah, I know.
No,
Sorry.
there is a, ya terminaste, because when I had him, there was a hold. ¿Ya terminaste con el caso en Wharton County?
Yes.
Okay, because when I had him, he still had a hold. If there is no more hold, that
They
means
run
that
an
the sentence.
NCIC?
Yes. Tengo que learn how to call it.
No.
I don't show
I don't
show another hold right now. I mean, there might be a warrant, but it's not attached to a spin that I can see.
It was
Ellos
there
no
when
ven
I
ninguna
had him.
What did he have in Wharton County?
¿Qué tenía?
If anything.
Other words, tenía algo.
It would have been a credit card or debit abuse. He was convicted
Abuso de tarjeta de crédito o de
on
It's
October
the same
15,
thing over and
2024.
over and over, you know, it's over and over.
Y dice que no lo puede hacer porque es la
It-
misma cosa de
it's-
vuelta y de
It
vuelta.
appears to me that Mr. Pasos Miranda continues to pick up the case
Sigue
over
agarrando
and over
los mismos
and over.
casos.
These fuel tax
Igual,
violations where
igual,
they
igual, o sea,
they allegedly get,
corrupción de-
you know what I mean?
Sí, pero-
So we've got one in Wharton, we've got one here, now we've got one in Yavapai County.
Se llama Pine County.
So is it because of the types of cases he's picking up, or
Not
are we
this
going
one,
back?
but
tipo de
it's- It keeps happening,
Okay.
right?
Sí,
It's
no es por el tipo de caso de que sigue
it's over and over and over for the last three
Yeah.
plus years.
What I was gonna
Mismo
do,
por
I
tres
thought we
años,
were
yeah.
going in a manner where I needed to figure out if he was aware of the warrant or not. But if that's not the case, and it doesn't make a difference.
Judge, may I jump in again?
Of
They,
course.
it looks like they lifted the hold
Parece que
on 218.
te quitaron.
If I'm looking on the DA portal,
Dos.
they placed a
18.
hold on him
Porque
on
pusieron una
October
orden de
31st,
detención
2024 for that
31 de
sentence for
octubre
7
para
months
la
state jail.
sentencia de
And then
7
they lifted
meses.
that hold
Después lo
on 218.
levantaron en
So he's
2,
done with that
18.
as of
Él ya
218.
terminó con él el
With,
18.
yes,
de
I can show
febrero.
it to you. Well, I don't know if I can.
How?
show- Because he came in on a warrant, so his time would have
Él
ran
vino en
concurrent
una
while he was in
orden
Harris
de
County
arresto.
and we were
Entonces,
working
Well,
out.
you know what it is? It must have been, you know, how on out-of-county cases, they give you the 10-day, right? And if they don't come pick you up, they release the whole within 10 days. That's what. it's
No,
probably-
well, so sorry, Judge. For this one, for the one on February 18th, that's for our 185th violation of motor fuel tax. That one, the release hold was on February 18, 2025. And then that triggered the in-county extradition for likely Wharton County for the out-of-county. That one was released on February 21st, 2025.
La orden esa te la quitaron.
But effectively, both of them, because they're state jail, it would have run concurrent. And at this point, based on when he was taken in, it's likely time served.
Which would be taking care of the Wharton County, and Wharton County is no longer in play because of the time he spent.
We don't
in
know
here.
that for sure, though.
We know that, well,
You
yeah.
know, right? So let's do this. Can we roll it to tomorrow and you can try to figure
Yeah,
out?
let
So
me
we can have
figure
a
out.
concrete, you know?
Let me get everything in place. I'll roll it, try to get some confirmation on Wharton and figure out if he had knowledge of this case out there or
I
not.
mean, I have a concern if he knows that this is open, because it's been open since 23.
Right.
Él sabe, esto está abierto desde
I have a problem.
I get it.
2023
I'm not gonna
que tenía
continue to,
una
like,
orden de-
Okay.
Let him
digamos,
slide when he knows he knows it's open.
y
Let me get all
sabía
this
que
in
estaba
place and
abierto.
we'll reapproach. Okay, let's do that.
Bueno, deja de hablar con él.
Okay, thank you, Judge.
Okay,
Thank you, Judge.
I'm here on two cases. The first one's on the docket, Malveau, Malveaux. Judge, this is the one we approached, and I've been back a couple of times trying to amend the condition for the mom. This is an alleged assault, family violence between a mother and a son. Ms. Malveau is here. The state has agreed, and I think they've contacted someone to change her bond condition to, we were just going to ask to allow for the texting and the phone call. And then you would ask them to do some follow-up rips.
So the defendant is mom,
Yes,
complaining witness's daughter.
this is the, I believe,
Daughter's
15.
21 or 20?
Son,
But
The
it's a son.
son is, he's 18, I believe he's a senior in high school. He's living with a family friend right now. And we are okay with amending bond conditions to allow communications over cell phones, so they can still text and call. But we would ask the court to
So-
hold any in-person contact.
and Judge, we would ask to allow her to go to his sporting events. No contact with him there, but she'd like to go watch him at track.
Now, I mean, it's
And the
invariably
football.
going to happen where she's going to get overcome with emotion. Then she's there. He's 2 feet from her.
Judge, he'd
Know
be
what I
on the
mean?
field and she'd be
It's
on the
like-
stand.
It's like holding a candy in front of a baby. I'm sorry, not a baby, but like a 13-year-old kid.
Judge,
you
I
know?
believe she could stay in the stands. And he'd be
Malvo,
on-
come up.
And he'd be on the field, but
I don't know. I mean, I don't think that's
Jose Montes?
it's setting up for failure right now. The only thing I want in the short life while I'm here is to protect every single complaining witness in these cases, in this county, in this state, as much as I can. And the problem is that temptation is so very high. We have at this moment a no contact order. You're not supposed to have any contact with this person. Your lawyer's asking for me now to allow you to have contact and texting privileges so that you guys can have some kind of communication. The state is still opposed to having you in-person contact. And the problem is that if you go to, and I'm inclined to, agree about in-person contact. The problem is that if we allow you to go to these sporting events and he's 2 feet away from you, the temptation is so high, it's invariably going to happen. And we're not there to see whether it happens or not. And so therein lies the problem, is that I will never be able to monitor the fact whether you actually have contact with this person or not. And that's a problem, because the last thing I want is you to pick up more cases or this person to get more hurt.
Talking about in person. Y'all have him as 18?
We actually have him in the updated record page 16.
Yes, Judge, he's 16. He's not
Like, it's
18.
The birth date was listed wrong.
It's okay.
And his father's in jail.
Remind me about the assault, please.
Sorry, Your Honor.
Refresh me about the assault, please. How bad?
So-
We're talking.
Yes, Your Honor. So the assault took place in June 2024, and the victim was identified, and the victim explained how his mother, the defendant, assaulted him by biting.
Biting.
Yes, Judge.
Yeah.
You see. So the victim stated his mother was angry that he was in the way, and as he was holding her 2 wrists, she raised her hand up to her mouth and raised his hand up to her mouth and bit his hand. The victim stated he felt pain, was in fear, and the victim had a visible bite mark on his hand.
Judge, the son is holding her first, just so we're clear on what's happening.
I mean,
Yeah,
Yes,
but
it does
he's
state
not
that.
quite saying that.
Well, it does
I
state
mean,
fully
what
that.
circumstances happen to where a 15-year-old grabs mom, right? I mean, perhaps they were fighting, I don't know, but the fact
Judge,
remains is that
there's been no facts and nothing in the probable cause that I've been given or that I've shown that any of this was between the mother and the son. I believe it was between my client and another lady, and the son comes and holds her. I believe that's what the
So-
facts will bear out.
he's trying to protect her. He's trying to, I guess, de-escalate the situation.
Judge, I believe that those would be facts that I would want to try.
Right, I mean,
yeah.
I don't know, and so, right, same thing, I mean, regardless, what we
facts
do
that-
know,
I'd want to bear out, but it's not like she just walked. I didn't want when you're making your decision for you to be basing it on, what it sounds like she walked up to him and bit him. That's not how it happened.
I get it, thank
Thank
you.
you.
Because,
Thank
and, I mean, the idea is that we really want to know under what circumstances everything happens. That's why with every case that we have here, we really delve into it as deep as we can to determine, is there probable cause? What circumstance should we have as far as contact or no contact? Guys, what do you think?
Judge, we're okay with them texting and calling each other to catch up.
What does he want? I mean, at the end of the day,
So
we need to find out what he
It's a little bit of a
wants.
complicated situation in terms of the complainant's guardian, because he is 15 and said he's living with a family friend.
16.
What we do know is that he does not want, to be living with the complainant, with the defendant. He wants eventually, I think his eventual goal is to get emancipated. We do know that, we talked to the person that she's living with and says that they have been texting already. So because of that, we're okay, and that they're
Are you
okay with
texting
it.
already in violation of a no contact order? If that's the case, I mean, I've got it. We'll take issue with that.
So, this was based on talking to this parent. She wasn't entirely sure.
Do we have a no contact order now?
I'm not entirely sure. And the other thing is that we haven't confirmed that with the complainant itself, a 15-year-old. So at this point, we don't have evidence to move on a
Right.
violation of a protective order or anything at that point. But it seems like the kid is okay with calling and texting, but hasn't.
But you don't know
indicated to us
that
they
for
don't-
sure, though. You don't know that for sure, right?
That's correct.
And Judge, as of December 18, 2024, there was a no contact order in place.
I hope that you're not having contact with this person. I hope, just, let's do this. why don't we set this off for a couple of days? If you could please reach out. I want to know what he wants or she wants.
Judge,
Taking her in school is really hard.
I want to honor the complaining witness's wishes.
we've,
This is that they just don't know.
well, Judge, can I just recount this? We've been asking them to know this. This is the very first time I was appointed, I approached you on this. You asked them the exact same questions. They've done nothing. They can't get in touch with the complaining witness. I came back on February 2nd. I came back on February 3rd. I came back on February 10th. I came back on February 11th. I came back on February
I mean,
12th.
I agree with her. That's kind of, that's,
Well, and that's why at this point, we are agreeing to have that full connection, which is what.
but you still don't know.
We have talked to the guardian, we just haven't to go talk to the kid. The legal guardian is an aunt who does not live with the complainant. Who we're talking to was a family friend, we've talked to her, we've given her multiple calls.
So,
We just haven't been able to get.
so let's do this.
Judge,
Let's-
that's a misstatement. The sister's not the legal guardian. The son is living with a family friend right now. His father's in jail.
The complaining witness is a boy or is it a girl?
He's living with a
It's a boy.
schoolmate,
A
Judge.
a friend from school.
He's living with a friend from
His
school.
dad dropped him
And she's
there.
gonna do a
And went to
BIP. The
jail.
chief has offered a BIP and dismiss.
I get it. I understand.
A BIP and a parenting class. Sorry. He did tell me that, Judge.
I understand, but I always want to honor the complaining witness's wishes, right? So let's do this. I do find it unreasonable that they've been here as many times as they have, and you guys have been unable to do this. So what I would suggest is do this. Reach out to them and say that we're going to subpoena them to come to court if they do not get in contact with you guys. Because I agree with you that it's unreasonable to have to come back 4 or 5 times just to see. So let's set this off maybe like 3 days, 4 days. Reach out to them and say, hey, we are going to subpoena you to come to court. If you guys, all we want to know is what's going on and whether you guys want to have contact and in-person contact as well. So ask everything so that you guys don't have to come back. Anticipate every single question that they're going to want known. So they can.
Yes, Judge.
So what we can do, so you don't have to waste your time coming to court. We can set it off 3 days, 4 days, and I'll waive your next appearance so you don't have to come here. And then she can reach out to you, phone that, because I don't want you to have to miss work or whatnot or anything. But I have to know what they want. And I don't want to work on speculation because
Is it what my son wants or is it?
it's what the son wants. I don't care what the guardian, I don't care who the guardian is. It's what the son wants. Right. I don't care about a guardian. It's not their decision. And I think that I'm now, 16?
16-year-old.
He's old enough to know, right? He's almost an adult, so he's old enough to make decisions on his own at this point.
And Judge,
Okay.
I've already accepted the PTI. We will get started on that. So even by this next setting where she doesn't have to appear, excuse me, Judge, she'll already be underway on the PTI.
Okay. I mean, parenting class is probably pretty short, so it's,
It's BIP and parenting classes, Judge. I'm sorry.
what is it?
It's BIP and a
Oh,
parenting class.
BIP and a parenting class. Okay.
I'm not really sure. I've got to figure out how long they want her in BIP and talk to her about that.
Got it.
So
Okay.
we can go sit down just for a second, then we'll get your
Okay.
case reset, okay?
Okay.
All right, we'll keep trying. Judge, I have one other one on docket today, and it's just a reset, and I've just been appointed today. Do I have to approach you on those? You've already found probable cause. It's Mr. Hall falsifying the drug
No,
test allegation.
no,
All right, then
no.
I'll just.
Just let him know that he's going to get drug tested about 50 days, just so
Sure.
he knows, and that's it.
Thank
Okay.
you so much.
Thank you, Ms. Peach.